Hello, everyone. It's Francis Widdowson here. It is Friday, February 20th, and today I'm going to be doing a video on my case with Mount Royal University, which, for people who've been following what I've been doing, has been a long and torturous process, and I would call it abusive because what MRU has done to me is outrageous. This should never have happened. And because the system is set up to protect the parties involved, which don't include me, it's the union and the university, it's very, very difficult when the whole process is flawed and you're trying to fight against that, which is what I've been doing since December 2021. Anyway, so what I've done is I've done a post on the wokeacademy.info site, and I've compiled some of the documents from the most recent development, which is the appeal that took place on February 6, 2026. And what occurred is that process was before this labor board, we had Mount Royal Faculty Association's lawyer, Leanne Chawley, making her arguments. Then we had MRU's lawyer, Michael Ford, making his arguments. Then Leanne Chawley responded. And overseeing it all was the board chair, who is then going to take all this information that he's received, submissions, which at this time cannot be released, and the discussions, and is going to go away and write up a decision, which is going to evidently be provided, he expects, within 90 days. And that decision is going to determine whether things should stay as they are or whether the decision should be sent back to the same arbitrator or whether the decision should be sent back to another arbitrator. So it's not over at all. And if it's decided just to keep things as they are, I'm demanding, or I'm putting forward the idea that it should be appealed to the courts so that we can get some justice about this matter. But we'll have to wait and see. And as people can tell, if it goes back to another arbitrator, that's going to be another 2 years that it's going to take. And of course, this is very, very difficult for the person who's in the position that I'm in, because of course I'm not employed and I'm waiting to be reinstated back into my job, whereas all these other parties are happily allowed to extend the whole thing for as long as they want. And it's only people who have serious gumption who are able to, continue, have the stamina to continue. So in terms of what I have done with respect to this post, is that it's on the wokeacademy.info site. And what it is it starts off with this kind of visual representation of what is happening, which is Mount Royal is trying to defeat me, and I am just fighting with everything that I have to hold them to account, which they really have to be held to account, and they have not yet. All these administrators who have done what they've done, it needs to be exposed and it needs to be understood. And the same with the union, but that's another matter that's going to happen at another time. And what you'll see when I go through these documents as this kind of image that I'm showing is argued by Mount Royal University to be a reason why I can't be reinstated. So my sense of humor with respect to putting up with what I've had to put up with for the last, over 4 years now is used against me. So it just is a really, really difficult position for me to be in, but I am not going to be intimidated, and I am going to continue to fight back against this. And so what this post does is it first of all gives you a bit of a background in terms of what's happened. So when I was terminated, what I consider to be the abusive process, which was the whole of 2023 with 30 hearing days. And then we had Arbitrator Jones. He issued his ruling in 2024. And if you're interested in this decision, which is a whole story in its own right, you can go into this post And there's a video that you can watch about it, which gives an overview of it. But what's important here that you should keep in mind is the actual case of harassment that was made against me. And that concerned one tweet involving D.A. Dirks, where I was satirizing the idea of misgendering fatigue and this LGBTQ initialism. The Gabrielle Lindstrom Weaselhead situation, which was me responding to Weaselhead harassing me. And there was 2 tweets that were found to be harassing. When I'm reacting to her, she comes onto my Twitter account when I'm just, doing a repost of a Titania McGrath thing, and she decides to come on and ask Tim Rowley. You can see this here. This is Weaselhead's quote here, post here. And this is what MRU is paying this person to do: troll fellow faculty members and students' accounts and then post threads of nonsense. And then when I replied, she mocked me and said that I thought I mobilized students against her. So I just needed to show how she had in fact mobilized students against me. And because she blocked me after she made that reply, that was seen as harassing because she had blocked me, which indicated she didn't want my attention. But she had just mocked me, and I was showing how what she was saying was actually incorrect, false. So I am able to defend myself. But MRU thinks that I shouldn't be able to defend myself, and defending myself is harassment in their view. And then the best one, which is the Hope report and the Watchman complaint. And there were 6 tweets involved in this, and you can see the tweets. You can just go in there, and they're not about anyone. They're satirizing MRU anti-racism, which was an anonymous account that was trying to, instigate this mob against me. So why is it harassment to satirize this anonymous Twitter account? And almost all of the tweets are like that, satirizing the comparison between the Holocaust and the residential schools. There was one mention of Renee, Michael, and Leah, who were doing an interview about MRU anti-racism. So I was just drawing attention to their using this Twitter account. And then Gabrielle Lindstrom, who's now Weaselhead, and Tim Haney, I was just responding to their commentary on me. And you can see from the attachments how they were actually involved in, trying to make all sorts of negative comments about me. So, but that was Renee Watchman was the person who made the complaint, not Tim Haney and Gabrielle Weaselhead in this instance. And Jeff Hope decided to look at all my tweets and say it was harassment of this person, Renee Watchman, when it concerned other people, which would have never happened in the Steve Eichler investigation, which I had when I was investigating my colleagues, 17 colleagues. That was one of his major concerns, which is, how do you know this is about you? Well, that thing about Haney and Lindstrom was not about Renee Watchman. So why is Jeff Hope incorporating that within his harassment findings? And these were some of the inconsistencies which were pointed out to the arbitrator, the inept and imperious arbitrator, David Phillip Jones, but he didn't care because, from what I could tell, he was there to uphold the views of the employer, which I will talk about at the end of this video. Okay, so my case involved 10 grievances, and then it turns out that the union decided not to appeal them initially. I had to try and get them to do that, and it was unsuccessful. And I found out it was because they had other grievances that they were pursuing on behalf of Dirks, Lindstrom, and Watchman. And they wanted to win those grievances. And in order for them to win those grievances, saying that I had created an unsafe, that MRU had not protected them from an unsafe work environment that I'd created by trying to defend myself, that in order for that to be successful, those three grievances, I would have to be found to be a harasser. And so therefore the union wanted to lose my grievance about saying that I had not harassed anyone. So anyway, that was a very depressing part of the whole story, which I have to wait to go after the union about. But it just shows you how flawed this labor relations process is and how I'm really dealing with a deck that has been stacked against me. So getting on to the appeal. So the appeal, as I mentioned, is not appealing the harassment findings or all the procedural problems, such as not being given the complaints, which is like a fundamental breach of natural justice processes. And there were 9 concerns that David Phillip Jones put forward saying that I could not be reinstated. And you can sort of see them here. Anyway, I'm going to go through all of these. So this is what he said. This is why he said I couldn't be reinstated. The union was showing how this was not reasonable, what he was putting forward here. And the Mount-Royal, the university, was saying that this was, completely reasonable. And also number 6, which is my behavior at the arbitration hearing, which was completely made up. The union's claiming that was a breach of natural justice processes. Anyway, so all this was going to the labor board, and what I've done here is during these proceedings on February 6th, I was taking a whole bunch of notes of the documents that MRU was putting up to justify these 9 reasons. So we have these 9 reasons that the arbitrator put forward as to why it couldn't be reinstated. The MRU lawyer was saying this is completely justifiable. This is very, very reasonable. And here's all the documents that are going to show how reasonable these reasons were that David Phillip Jones put forward. And so I just want to take you through these. You can take a look at these documents yourself if you want to. But they're quite interesting. And so what I've done is I provided the reason that Michael Ford was looking at, and then the evidence that he gave, and you can judge for yourself as to whether you think this really makes sense that I can't be reinstated because of this evidence showing these things. So number 1, the first reason was the adverse effect of my participation in the Twitter war from the middle of 2020 to the middle of 2021 on her relations with a number of colleagues at MRU, which in my judgment cannot be repaired. And so the union is arguing that because it's not stated who these colleagues are and why it's so important for this relationship to exist, that's not reasonable. But Michael Ford was saying this is completely reasonable because there's all this evidence. And so what he provided was 3 paragraphs from the arbitration decision about the arbitrator's views on the impact or the lack of repairing of the relationship with Renee Watchman, Gabrielle Lindstrom, who's now called Gabrielle Weaselhead, that's her maiden name, and Tim Haney. And so, first of all, Dr. Watchman is not at MRU anymore, so I don't know why we're talking about her. And as you would see if you look at the arbitration decision, none of my tweets were about Renee Watchman, except in the context of her participating in the Mount Royal Anti-Racism Coalition. I don't work at all with Dr. Lindstrom Weaselhead, so I don't see why my relationship with her has to be repaired. And the same goes for Tim Haney. But of course, Gabrielle Weaselhead figures very prominently in this whole thing is because she doesn't feel safe with me being at MRU. So just the thought to her that I would be at MRU, maybe walking down the hallway from now and again, when she might bump into me, this is something that she finds to be very upsetting. And because she's a prized indigenization asset, her views are going to be considered more than mine. And Tim Haney, because he added the word genocidal to a motion, which I was criticizing. And I said, has MRU lost its mind? Not has Tim Haney lost his mind. Because, MRU is now making a statement about the residential schools being genocidal, which is a political statement, and they shouldn't be trying to enter into these debates. They should allow faculty to do it. So this whole support for lack of repairing relationships really it doesn't stand, because I don't work with these people. I don't need to have good relations with them. That's what it's all about, and that's not the case. And Michael Ford also put up this section from the arbitration decision, which talks about that my harassing tweets had a deleterious effect on others in the workplace, and that my harassing tweets did contribute to a toxic workplace. Well, my tweets were all in response to a mob that was trying to get me fired. According to Steve Eichler, provocation means that it's not harassment if you're just responding to people provoking you. So under that standard, it wouldn't be harassing. And, that's kind of the thing that needs to be considered here. I wasn't going after anyone. They were going after me, but no one seems to care about that. That was the evidence for the first one, which is that my relations with colleagues can't be repaired. Number two, her refusal to recognize the impact of her harassing social media communications and her lack of any remorse for making them. So, impact. What is the impact? Some tweets. Is that really had significant impact on people? I think that's valid to question that. And plus, in terms of my reaction to what was being done to me, I really think, if anyone had a serious impact, it was me, who has had a whole bunch of people trying to get me fired. And that's what I was saying to Elizabeth Evans, is that first of all, she wanted me to accept responsibility and show remorse. One thing the arbitrator never recognized was that evidence was presented to him 3 times at the arbitration hearing about how MRU did not think that social media was covered by its policies. That was something that was revealed to Milena Razankowska in 2019, December 2019. The arbitrator didn't notice this evidence at all. So really, the whole case should have been thrown out on that basis, because the collective agreement says you can't be punished for violating a rule that you didn't know existed. And this rule didn't exist until MRU wanted to go after me, and then they changed its policies, which again shows bad faith, which the arbitrator should have picked up on, which he did not notice. Anyway, so let's look at the evidence that MRU presented in terms of the impact of my harassing social media communications and my lack of remorse. And he gives, this is from 444 in the fundraiser, so that's the circle on the left, that many of the items on the Woke Academy and Facebook sites, he's referring to that. There's a link to my episodes about the Watchman complaint. There is some commentary on the arbitration hearing. There are articles from her presentation to the Society for Academic Freedom and Scholarship on her case. She told funders that studying the residential schools was one of the major issues that resulted in my firing, which was my, when I was satirizing, right? That was Renee Watchman, who said that when I was saying that comparing the residential schools to the Holocaust was a ridiculous comparison. That was found to be harassing. And then there's 460, paragraph 460, where Provost Brown has specifically told me that the personal harassment policy, and I should look at that. I don't know why that's being provided by Michael Ford. Oh, I said that I did not understand that there be a civility requirement in the collective agreement, which I do not believe there is a civility requirement in the collective agreement. She agreed that she has made a name for herself about wokeism and academia. She believes the faculty association has been politicized. She wants the university to become an academic space once more. It's going to come up time and time again. This is somehow seen as being a problem, me wanting the university to become an academic space once more. I don't agree with the harassment and discrimination limitations on academic freedom. And academic freedom, properly understood, is about ideas. So that's what I'm talking about. Not that I don't think that it is that academic freedom covers me going and constantly berating my colleagues and doing things like that. But if I'm trying to compare the residential schools to the Holocaust, I'm saying that comparison is ridiculous, and I'm doing it in a very kind of unorthodox way through satire. I don't believe that's harassment. Satirizing ideas is not a harassment. That's my position. And then he talks about that I showed no remorse from my conduct. That Provost Evans supposedly realized this, even though I never said that in that meeting, which was in May 2021. So this is all evidence of refusal to recognize the impact of my harassing social media communications and lack of remorse. So those 4 sections of the arbitration decision of Jones, 444, 460, 463, and 591. Those are the paragraphs, and you can take a look at them in the arbitration decision. The other items that Michael Ford put up were this, and there's links here. So I just want to provide people with all the evidence, and you can take a look at them yourself. And you can enter into, okay, that link. It'll show you, sorry, that's a Renee Watchman complaint. So this complaint, this post on the wokeacademy.info site, which is linked to in the attachment that I provided on the wokeacademy.info site, it just provides facts. So it's not saying anything negative about Renee Watchman. It's not calling her names. It's not doing anything. It just is, showing, and you can, and I'm trying to link there, but it's not allowing me to, it just keeps on advancing. Anyway, you can take a look at that whole thing on the wokeacademy.info site. So I don't see how that is showing I don't recognize the impact on my colleagues and shown no remorse. This summary that I'm talking about, was Renee Watchman's complaint against Francis Widdowson emboldened by university indigenization? So I say yes, it is. Yes, it was, right? Because Renee Watchman thinks that any criticism of indigenization is personally harassing her. That's what I see in this summary. So is that not recognizing the impact and not showing remorse? So then we have Gabrielle Lindstrom, now goes by the name Gabrielle Weaselhead. It's episode 12 on the wokeacademy.info site. You can go into that if you want to take a look at the whole thing. But what I've done is I've just documented all the harassment that Gabrielle Lindstrom was involved in. And again, I didn't call her any names. I wasn't attacking her. I'm providing factual information that people need to understand, because Gabrielle Weaselhead is now saying that all the harm that she had to experience from me, everything that Gabrielle Weaselhead endured was a direct result of her trying to get me fired, mobilizing an anonymous student group against me. Again, we have a summary which is the next attachment, which is Michael Ford was going over, and it was, why did Mount Royal University insist that Francis Widdowson accept responsibility and show remorse for her conduct? And here I'm explaining that I stated that I could not accept responsibility for my actions because this section of the collective agreement stated that I could not be disciplined for a rule that I didn't know existed. And as well, remorse was I was just reacting to people trying to get me fired. So this is, again, what the evidence that MRU is using. This is about the wokeacademy.info site. This graphic, evidently I can't be reinstated because I'm putting forward that graphic, which I think is a very good, visual representation of what's happening. MRU, with all its resources, spending millions of dollars on legal fees, has just no one's out of a job. Everyone can spend as long as they like. And here I have to sit and wait for 5, 10, maybe even 20 years to get justice about this situation. When satire becomes harassment. So this is an article in Minding the Campus, which is a journal associated with the National Association of Scholars. This is protected under academic freedom. And again, I'm attacking people. I'm not. I'm explaining how satirizing ideas, and that whole thing that happened, essentially the Renee Watchman complaint, how that got turned around. Satirizing ideas is not harassment. It is a mode of trying to draw attention to the absurdity of the ideas that are being put forward. Number 7, seventh document he put up is the terrorization of Francis Widdowson by MRU's Human Resources. That is just relaying the accounts of what happened on December 20th when I was lured into a classroom after hours. And when I said I needed union representation and tried to leave, Mike Quinn blocked my way, which caused me to become incredibly distressed due to my history. And I ended up calling 911 that day. That's how bad everything got. Anyway, it just relays all the events. It's not attacking anyone. It's not doing anything. Fundraiser website where I had this graphic. You belong here. I just said only some belong, which is true. I don't belong. Michael Ford was saying that it was discovered that I just didn't really fit in the milieu of Mount Royal, and that I couldn't play in the sandbox with others, and that I was a square peg in a round hole. Isn't that saying that, the "you belong here" slogan is not really accurate? Anyway, they're seeing this as a reason as to why I should be reinstated. And then the 9th document that's put up is the rigorous due process on the wokeacademy.info site. So I provided 18 episodes on the wokeacademy.info site, and this just goes through all the procedural problems that should have been appealed by the union, but which were not, because of the fact that they're not representing me fairly. Anyway, there's nothing wrong with this. It's totally academic. It's not, involved in name calling or acting disrespectfully or any of these kinds of ways in which these actions are being labeled by MRU. As well, MRU put up these 2 paragraphs from the arbitration decision, 464 and 465, talking about how I said that the union is not representing my interests. And it's basically my criticisms of the faculty association, which the collective agreement protects us in our ability to criticize the faculty association. So what's the problem here? And that I didn't get MRU to help me, or the MRFA to help me with my rebuttals, because I sensed that they were not acting in my interests at the time, which they were not. So that's number 2, which was my refusal to recognize the impact and my social media communications and my lack of remorse. So some of them are about refusing to recognize the impact. Others are about my lack of remorse. But I think if you look at those documents, it seems absurd that I can't be reinstated on their basis. Reason 3, the reluctance of a number of witnesses who were co-workers to see her return to the workplace. So some people at MRU are reluctant to have me return. Why is this a reason anyway? Isn't it whether that's a justifiable reluctance? Like, for example, Mary Lee Mulholland, who's the chair of sociology, is upset because I say that there's only 2 sexes. She thinks that denies the humanity of trans people. Is the fact that Mary Lee Mulholland is reluctant for me to return because of this kind of reasons? Does that make sense why I should be reinstated? And besides, I don't work with Mary Lee Mulholland. The only one who I work with is Dwayne Bratt, and I rarely work with him. Like, I sometimes am in a departmental meeting, but it's like we don't cross paths a lot. So this is all just made up. So in terms of that number 3, I don't believe they showed. Yeah, so there's no documents that were put forward to support this. It was really just mentioned a whole bunch of names of people testifying in the arbitration here. So that's not giving us any evidence to work with. It's just vague references. Number 4, her persistence throughout the arbitration hearing that none of her tweets investigated by investigators about harassment were harassment. And although I grudgingly agreed that she would now not make the tweet referring to DA Dirks. So that was my one concession, is that I had this colleague when I was doing that tweet about the misgendering fatigue. I still don't consider it to be harassment because it was satirizing an idea. Misgendering fatigue, it was not, as it was claimed, about trans identities. But still, DA Dirks was not attacking me on social media, so I should have made it more abstract about just the idea of misgendering fatigue and the LGBTQ initialism. There was no need to bring Dirks into it. But in terms of Lindstrom and Watchman, I did not harass Gabrielle Lindstrom, Weaselhead, or Renee Watchman. None of my tweets were about Renee Watchman, which was a fundamental reason why Steve Eichler thought that you were being harassing. It had to be about the person that you had your tweets there about. And Lindstrom was going after me, constantly going after me, and I would just react to her. I was just reacting. So, and the fact that Lindstrom was hired back right after I was fired, that just shows to me that there's, I needed to be got out of there because of Lindstrom feeling unsafe. She resigned in, I think it was October 2020, because she said I made her feel unsafe for defending myself from her harassing. Okay, so in terms of this 4, what is this that none of my tweets, or persistence that none of my tweets were harassment? Well, it's true. I don't think they're harassment. So I don't understand. I've got really good reasons for putting forward these arguments. Am I just supposed to abandon them because Nadia Rentz, who was the investigator of Lindstrom, and Jeff Hope, who was the investigator for Watchman, that those investigators hired by MRU, they're arguing their harassment? I'm just supposed to defer to them, even though Eichler, who was also an investigator hired by MRU, who was investigating the complaints that I had filed against 17 colleagues, his standard would have meant that I would not have been found to have engaged in harassment if that had been the case. So what about that? I'm not just being belligerent for no reason. I have good reasons. And this is kind of really upsetting about this process. It's like David Phillip Jones is an arbitrator. He's a human being. He has arguments he's putting forward. I'm challenging him. I don't respect his opinion on this matter. But because he's in this position, it doesn't matter how unreasonable, irrational his ideas are, I'm expected to defer to them because this is the nature of labor relations, and I can't have my job back unless I submit. Well, it's not going to happen, right? You're going to have to put a gun to my head before you get me to admit I've done something which I don't think I've done. So I think that's abuse. This is psychological abuse, what's happening. So that's for number 4. That's the evidence. Number 5, my post, and this is the big chunk that came here. I think it was number 2, right? A refusal to recognize impact that had like 9 attachments. Her post-termination conduct in her blogs and websites demonstrate a hostility to the university and to colleagues. So, hostility. I'm critical of them, and the collective agreement protects faculty members' ability to be critical of the university and to colleagues in a respectful way. Right? The idea is you're not supposed to be disrespectful. So that would have to be the way. Now, of course, that's a fraught term. So let's see what they did. So they had this article, Exclusionary Inclusivity, how the Mount Royal Faculty Association's woke faction coerces conformity. That was an article in Minding the Campus. Again, a scholarly article in a journal of the National Association of Scholars. This is protected by academic freedom. And what it does is it just talks about this retreat program and how it's designed to prevent ideas from being criticized. That's what it was all about. And then we have how MRU and the MRFA has been basically captured by this ideology, whether it's equity, diversity, inclusion ideology, wokeism, the idea that you must affirm the identities of oppressed groups, and if you don't, you're going to be subjected to various harassment proceedings. This is what's happening. Let me have some notes of the next one is the Woke Academy's rejection of the rule of law. This is Minding Campus again, a scholarly article talking about the lack of due process that happened, how procedures are skewed to favor those with woke ideas, and you don't get the same protections. And that's the nature of wokeism, is that they argue that the entire system is, infused with white supremacy. So you have to level the playing field by giving people who are perceived to be oppressed more protection than those who are considered to be an oppressor. That's punching up and punching down is often what it's seen to be. Anyway, he provided a number of areas of this. I was talking about how the faculty association had been compromised. I was talking about how both the union and the administrators were suppressing dissent in universities, and the union was, this as well. The woke faction now embraces equity, diversity, and inclusion. And they have that in their website. You're supposed to be supporting that. And here I'm talking in the comments of that article. So they're going into the comments, talking about the union, the problem of the union, how it's not representing me fairly. I'm allowed to do that. It's in the collective agreement that you can criticize the union. How reified postmodernism is killing the Mount Royal Faculty Association. That was in SAFS newsletter in April 2021. So that's when I was employed. This is before I got fired. No one was disciplining me or telling me that I couldn't do that when I was an employee. So now they're going to use it against me in 2026. And it was funny because Michael Ford said, he said, I was talking about killing the Mount Royal Faculty Association. So he did a bit of a slippage of words, which we don't know was intentional or not, where it made it sound like I was advocating the killing of the Mount Royal Faculty Association. And then he's talking about my criticism of the union and how wokeism has entered into how the union conducts itself. Again, how is this grounds for a lack of reinstatement? Is the Mount Royal Faculty Association acting in good faith? And again, I'm not attacking anyone here. I'm just showing what happened with respect to the union and how the union treated me. I need to talk about these things. It's important for people to understand the nature of my case and how it's reflective of what's going on in many other areas, many other universities. And then this is an article. So this is interesting as well, because this article was, this interview was done in October 2020. So I was being mobbed at Mount Royal, and I did an interview about that mobbing. They see this as evidence that I can't be reinstated, even though I was never investigated for any of this discussion that happened in October 2020. And the particular area they take issue with is the politicization of faculty associations. So again, criticizing the faculty association is not allowed according to MRU. This is nonsense. This is in the collective agreement. You're allowed to criticize the faculty association. It's protected. So why is something that's protected for faculty members being used as a reason as to why I can't be reinstated? All eyes on the arbitration of the Francis Widdowson case. This was in the SAFS newsletter. And this is one thing that Michael Ford zeroed in on. I'm talking about the unfair and secretive processes and how the union didn't seem to care about this. They didn't care that I hadn't been given the complaints for the investigations. So a lot of things were withheld from me before I was going through these investigations. That's a natural justice issue. You need to know the case against you, and I didn't know the case against me. There was information that I didn't have that I could have used in my defense. So this is seen, and the union representative who was talking to me when I was bringing this up said that, you know, I should have a nice beverage and a box of tissues on hand. That's the advice she gave. You know, I thought that's not going to cut it. You know, first of all, I don't need to have tissues here. That is really infantilizing, as if I'm going to be crying while I'm being persecuted by, you know, the university. You know, bring it on. That's what I say. Failure of duty or fair representation. Again, this is criticism of the union. My fundraiser site was brought up where I said, questioning woke ideas, which I was. That's why I was fired. They're saying that's harassment, but that's because they see criticizing woke ideas, satirizing them, as being harassment. So saying I'm criticizing, but that I'm being fired for harassment means I'm being fired for satirizing woke ideas. And they say, well, it's violation of academic freedom and freedom of expression, natural justice, and procedural fairness. I don't understand. Like I'm explaining why I was able to be fired, and that happened because of wokeism and because of all these procedural problems, weaponizing harassment policies to prevent people from criticizing ideas which are sacred cows in the university. Again, we got these fundraiser updates, role played by the Mount Royal Faculty Association. So this, what happened is, at this time I was discovering that I was discovering that the union was acting against me. And I really found out this in 2024 after the arbitration decision, because the Kelly Sundberg, who was the senior grievance officer, was encountering all sorts of opposition to trying to defend me, and he kind of, in the documents that I saw that he had, it showed the union was really acting against me. Anyway, so I was trying to get these documents. I decided, because it would take too long, it would have disrupted the arbitration process. I decided to pursue that at another time. But I don't see the, I'm just alerting people to the problems of the faculty association. Non-existent case. MRU had a non-existent case. Me saying it's a non-existent case is seen as reasons why it can't be reinstated. As you saw from the tweets, that's the harassment case. And I still think it's just, there's really nothing there, but they're making it this big mountain out of a molehill. It would never have been thought to be harassment if someone else had done it, but they're trying to get me out, and they're using that as the reason to do it. And then it's talking about how I'm talking about wokeism and MRU at other venues. I'm allowed to talk about my case. I'm allowed to criticize what's happened. Now, of course, the arbitrator in, I think it was June, when I was talking about my case, he told me I couldn't do it. So I was under an order that I had to abide by, which I did. But up until that point, I thought the problem was talking about witnesses and what witnesses were saying. I didn't know was I couldn't say, I think it's a non-existent case. That's what I thought. I was able to say that. I thought it was about tainting witnesses. I thought that was the issue, which I was not tainting any witnesses by revealing their testimony or saying anything like that. And then I'm talking about the arbitration process, that I was very angry about it, because I had to spend a year in arbitration because it was not particularized, and we didn't even know what MRU's case. They went on a big, huge wild goose chase trying to get all sorts of things. So that was very, very frustrating. And I'm criticizing it. I don't understand why I can't criticize the fact that I had to be, subjected to all these things for, years on end. And the money that's been made by the law firms is incredible. And then I have to sit twiddling my thumbs. Hundreds of thousands of dollars, millions. What does the government think about this? What does the public think about this? That instead of managing the workplace properly and telling Gabrielle Weaselhead and Renee Watchman that I'm allowed to criticize indigenization, they enable these people because they're members of oppressed groups. And I say there will be no plea bargain or non-disclosure agreement. Exactly. There won't be. There will never be. I'm supposed to stop saying that? This is my saying that means I can't be reinstated? I had a lawyer, legal intervention. And that is about these documents that would show that the union was acting against me. This is going to be a matter after my case comes to a conclusion. So that was 5, which is my post-termination conduct. So that conduct, these articles I'm writing in Mind the Campus, completely academic, not calling people names, my criticizing the union, this is seen as a reason for not reinstating. Okay, number 6, that was my behavior at the arbitration hearing, where I had to be admonished for speaking to witnesses, and that I was eye-rolling and snickering and talking under my breath was the claim that Michael Ford made. And that never happened. That never happened. And I said this to the union. The union wanted to make submissions to give our side. The arbitrator would not allow those submissions to be made. And then he has the nerve to put this in as one of the reasons why I can't be reinstated after shutting down the union. And I thought personally that was a clear indication of Jones's bias. But because everyone reveres David Phillip Jones, you can't even hint that he's done anything improper. So that was all just testimony from Sarah Godwin, who was a lawyer, her affidavit. There was nothing, there was no documents that were put up by Michael Ford. Number 7, her refusal to accept the terms of her employment relationship are determined by the collective agreement, which defines both academic freedom and her criticism of the faculty association for agreeing to these limitations. This one I've never understood. I don't know what the evidence is for this. I'm arguing that academic freedom includes the ability to satirize ideas. That's what I'm arguing. Now, the union might have a different view, and maybe we'll change. And this is all up for debate in this arbitration process, but my having that opinion is seen as not allowing me to be reinstated. And I never said that if it had been decided that satirizing woke ideas is harassment, then I'm going to have to, I'm going to have to rethink I'm going to have to talk about how that I'm not going to do that, or I'm going to have to think about it, but I'm going to still make the argument that it is not harassment, whether I do, I'd have to abide by whatever things are put on my head because I'll lose my job, but those are different matters. And then that's the evidence that's given for that it's about the faculty association, criticisms of the faculty association, and the rebuttals that I didn't use the union in writing my rebuttals. So what was that? That was that's the evidence given for that I refused to accept the terms of my employment relationship are determined by the collective agreement. I'm arguing about the interpretation of the collective agreement, not saying that it doesn't apply. That was the one piece of evidence that MRU presented for number 7, that I'm criticizing the union for being subject to wokeism, and it's been acting against my interest. I don't understand. That's got nothing to do with number 7. Number 8, the friction between her colleagues and other colleagues, not just between her and other colleagues, sorry. The breadth of the Lindstrom and Watchman complaints, which go far beyond this harassing social media communications. So this is an interesting one, 8, because the ones that went far beyond the harassing social media communications were protected by academic freedom. So what Jones is saying in this number 8 is that the friction that's caused by me making arguments is a reason why I can't be reinstated. And that's shocking. That's shocking that he would completely be in favor of violating my academic freedom rights because that would cause friction with Lindstrom, because Watchman is no longer at MRU. So why is he even talking about Watchman? It's got nothing to do with the workplace at all. And as we've seen, Lindstrom doesn't think I should be able to discuss indigenization, thinks that, talking about the residential schools and the unmarked graves is really offensive, and that, you've got to accept the residential schools are genocidal. This is her attitude. And that's not something that's consistent with an academic institution. And then finally, number 8 is just his 637. This is just the same thing. So it's the part of the arbitration decision, paragraph 637, where he says that. That's the only evidence, is that paragraph. And then 9, given her implacable views and attitudes, reinstating her would not be a lasting or final solution. And implacable means very difficult to change. Now, I certainly am insistent on following through with ideas if I think they're valid. But if you give me evidence that shows me that they're flawed, I will change my mind. So I think characterizing me in this way is really prejudicial. But there's some things which I will not capitulate on. I will not submit because I do not think that submission is called for under reason, evidence, and logic. And 3 attachments are provided to give evidence for this claim, and 2 of them are unbelievable. The first one comes from the fundraiser site, and when I kind of provide these episodes, so I provide these linkages to these episodes, and then I say at the end, my case must be won, and I will fight to the end to make the university an academic space once more. That is what is being used by MRU to claim that I am implacable views and attitude. Should I give up on fighting to make the university an academic space once more? That means that we're not going to have academic institutions anymore. So that's shocking. And then again, this article from October 2020. So this was a year before I was fired. No one ever mentioned this to me. It was not an issue with MRU, which is now trying to use to prevent my reinstatement again. So I just say here that I'm going to fight. I will continually publicly criticize all efforts to take me down, that I'm dug in a big way, and I will fight to the end to make the university become an academic space once more. So this was said in October 2020, and I continue to believe this. I continue to do that. And you would think that universities would value having someone who actually believes these things, is going to fight for the university as an intellectual entity. But this is seen as a problem. And then the final one is from my Facebook page, where, and this is actually when I was being harassed by Rick Mehta. And he was constantly saying that, that I was an idiot because I was expecting to be reinstated. And I knew very well at the time that the union was acting against me. So I was aware of the problems, but I said that I am demanding to be reinstated, not expecting it. The demand is to force a reckoning of whether MRU is a woke university or an academic university. So I am trying to restore MRU to become an academic university and to stop the wokeism that is directly interfering with the academic mandate. And so I think that is a valid position to take. It should not be held against me, and it should not be a reason that is given for why I cannot be reinstated. So that is the entirety of the evidence that Mount Royal presented on February 6th. And this raises, what is going to be the outcome. Now, in a sane world, I would be back in the classroom this year. In a sane world, this would never happen. But now that people are, seeing and after February 6th, when that's the evidence, this is the things that I should be doing are being held against me, trying to defend myself. I'm not allowed to do that. I've got to just sit and wait and take it and have Renee Watchman and Gabrielle Lindstrom at Weaselhead just, saying all sorts of untrue things and not respond. This is kind of the expectation. But the problem is that The system is very deferential to the actors that are in it. And you can see this from Jones's decision on paragraph 592. And he says here, when he's overturning the discipline, so the 2-week suspension that I got for those 3 tweets, which the one was on the misgendering fatigue, the 2 were reacting to Lindstrom's harassment of me, which is just nothing. He says he's going to overturn the discipline. And in reaching this conclusion, I am well aware of the appropriate reluctance of arbitrators to closely second guess the level of discipline imposed by an employer on an errant employee. So why is there appropriate reluctance to second guess the level of discipline? Like, that's what arbitration is for, is that you have a dispute between the employer and the union about what happened. So why should there be any reluctance? It should just be, you're going to follow the evidence wherever it leads. There shouldn't be any predetermined way of approaching this. And that, when I read that, I was very, very concerned about the situation. So anyway, what happened? So in terms of the arbitration process, which happened in 2023, you can read about that arbitration decision on the wokeacademy.info site there, and you can and I provided every single piece of evidence, information about the harassment findings. As well, I did an analysis of how the findings were different depending upon whether I was being investigated, which was by Investigator Rents, by Investigator Hawkins, and Investigator Hope, versus how 18 other colleagues who I had filed harassment complaints against were investigated. Those investigations were done by Steve Eichler, and Steve Eichler's bar for harassment was much higher. As I said, if you were provoked, it wasn't harassment. If it was one time, it wasn't harassment. So Dirks, that was one tweet. That wouldn't have been found to be harassment just because it was one tweet. It had to be about the person that you had filed the complaint against. So that would have knocked out all those tweets in terms of Watchman's thing. And I did an analysis of this, and this was presented to some extent in the hearing. So, the fact that I'm continuing to make the arguments that I was not harassing anyone, which are completely valid, because I'm not deferring to the investigators who are paid for by MRU, this is seen as being a huge problem. Like, as a professor, you're supposed to use your intellect to be able to understand things. That's what you're supposed to be doing, and they're punishing me for doing this. So that's the situation coming in. And now with this February 6th hearing, as you've seen from the evidence that I've provided, MRU put up 33 kinds of instances of these reasons that Jones had provided. It provided a number of sections from Jones's decision. Everything they're talking about, they say this is attacking people. I'm legitimately criticizing, respectfully criticizing MRU, the union, and as well just presenting facts about what it is that Renee Watchman and Gabrielle Wieselhead did and what their arguments were. And they're making all sorts of attacks about me, which are actually attacks. They're acting as if I'm some kind of morally deficient person. I'm not doing that with them. I'm just saying that the whole indigenization process has emboldened them and goes against the academic mission. So in terms of what has happened, all I'm trying to do is publicize things. I think people should know what the terrible situation is in universities these days. I believe that my case is one of the most important academic freedom cases over certainly the last decade. Anyone who cares about universities should be paying attention to my case, and will find out sometime probably in March or April, whether this case will be sent back to another arbitrator. Thank you very much for listening.